Welcome back to Nyay Patsala. Today we will be exploring section 216 in chapter 17 of the Code of Criminal Procedure. Section 216 of the CrPC gives court a unique power. Under section 216 CrPC, the court can alter or add new charges against any accused person during a trial and at any time before pronouncement of judgment. Imagine a situation where a trial is going on and suddenly new evidence comes up. The court sees this and decide it's necessary to add or alter the charges. This is precisely what section 216 of the CrPC is designed to handle. Section 216 of the CrPC states as follows. 1. Any court may alter or add to any charge at any time before judgment is pronounced. 2. Every such alteration or addition shall be read and explained to the accused. 3. If the offence stated in the altered or added charge requires previous sanction for prosecution, the case cannot proceed until such sanction is obtained. However, if sanction has already been secured for a prosecution based on the same facts as the altered or added charge, this requirement does not apply. 4. If the alteration or addition is such that proceeding immediately with the trial is likely in the opinion of the court and it may prejudice the accused or the prosecutor, then the court may either direct a new trial or adjourn the trial for such period as may be necessary. Number 5. If the offence stated in the altered or added charge is one for the prosecution of which previous sanction is necessary, then the case shall not be proceeded with until such sanction is obtained. And unless such sanction has been already obtained for a prosecution on the same facts as those on which the altered or added charges is founded, then the court can exercise this power. One should remember that section 217 of the CrPC deals with recalling of witnesses when the charge is altered or added by the court after commencement of the trial. Under subsection 4 of section 216 of the CrPC, if the alteration or addition which in the opinion of the court will cause prejudice to the accused or the prosecutor, the court may either direct a new trial or adjourn the trial for such period as may be necessary. But if the offence stated in the altered or added charge is one of which previous sanction is necessary, then the case shall not be proceeded until such sanction is obtained. Unless sanction has been obtained for a prosecution on the same facts as those on which the altered or added charges is founded, the court will not proceed. After section 216 CrPC, we should look into section 217 of the CrPC also. Because section 217 of the CrPC deals with the recalling of witnesses when the charge is altered or added by the court after commencement of the trial. Now let us look into the explanation of the phrase at any time before judgment is pronounced. The use of the words at any time before judgment is pronounced in subsection 1 empowers the court to exercise its powers of altering or adding charges even after the completion of evidence and arguments have been reserved for judgment. So at any time before pronouncement of the judgment, the court can alter or add a charge. This alteration or addition of a charge may be done if it is in the opinion of the court that there was an omission in the framing of charge, number 1, or if upon prima facie examination of the material brought on record, it leads to the court to form a presumptive opinion as to the existence of the factual ingredients constituting the alleged offence, then the court may alter a charge or add a charge. So what is the test to be adopted by the court while deciding upon an addition or alteration of charge. The duty of the court is to see that the material brought on record needs to have a direct link or nexus with the ingredients of the alleged offence. Addition of a charge merely commences the trial for the additional charges, which based on the evidence it is to be determined whether the accused may be convicted for the additional charges. We must remember that the court, while exercising its powers under section 216 CrPC, has to judiciously decide and ensure that no prejudice is caused to the accused and that he is allowed to have a fair trial. And in this regard, the only constraint on the court's power is the prejudice likely to be caused to the accused by the addition or alteration of charges. Subsection 4 of section 216 of the CrPC therefore prescribes the approach to be adopted by the courts where prejudice may be caused. Now let us examine some case laws in respect of section 216 of the CrPC. In the case of Anand Prakash Sinha versus State of Haryana, reported in 2016 6 SCC 105, the Honorable Supreme Court held that the charge can be altered by the court at any time before the pronouncement of the judgment, but it must be based on the materials available or subsequently brought on record during the course of the trial. The next case one should look into is P. Kartika Lakshmi versus Sri Ganesh, which is reported in 2017 3 SCC 347. In this case, the Honorable Supreme Court, while dealing with a case where during the course of a trial of an offence framed under section 376 of the IPC, in that case, an application under section 216 was filed to frame an additional charge for an offence under section 417 of the IPC. In this judgment, Justice F.M. Ibrahim Khalifullah observed that section 216 of the CrPC grants courts the exclusive right to modify or introduce new charges at any stage before delivering a judgment. One can invoke this authority by any party as a matter of right through an application. But the court must identify an omission or the need to change a charge during a trial, because it is the discretion of the court to make such changes independently without needing a formal order for this purpose. Once the changes are made and the final judgment is delivered, the parties then can seek legal remedies based on the revised charges. The next case is CBI versus Karimullah Oshan Khan, reported in 2014 11 SCC 538. In this case, the Honorable Supreme Court emphasized the broad powers granted to trial courts under section 216 of the CrPC. The Honorable Supreme Court, through Justice K.S.P. Radhakrishnan, stated that trial courts can alter or add charges at any stage of the trial. Listen carefully. The trial court can alter or add charges at any stage of the trial, even after completion of the evidence, as I have already spoken, or after hearing of the arguments and reservation of judgment. Also, the charge can be altered or added. But such changes must be made in the interest of justice and without causing prejudice to the accused. This is the most important test of section 216, is that any changes, it should be made in the interest of justice and should not cause prejudice to the accused. Section 216 of the CrPC gives all courts, including designated ones, the authority to modify existing charges based on the material that it is directly related to the charges. Of course, this power is subject to specific conditions and procedures outlined in the CrPC. We must remember that the alteration or addition of charges is contingent on the relevance and connection of the new evidence to the existing charges. In the case of Jasbinder Saini versus State Government of NCT of Delhi, which was reported in 2013 SCC 256, the Supreme Court through Justice T.S. Thakur, who was presiding the bench, affirmed that a court has unfettered power to modify or add charges at any point before delivering its judgment in terms of section 216 of the CrPC. The said case involved the question whether it was appropriate for a trial court to add charge under section 302 to the accused who were already charged under section 304B IPC. In this case, the court highlighted that a process for such alteration is outlined in section 216 CrPC, and section 217 of the CrPC addresses the recall of witnesses when charges are changed after the trial has started. This decision of the court to modify or add charges typically arises when a court identifies flaws in the existing charges or deems it necessary based on new evidence presented during the trial. The Honorable Supreme Court has elaborately discussed the duty of the court when adding or altering a charge under section 216 CrPC. In the case of Dr. Nalapa Reddy, Sridhar Reddy, kindly take note of this citation, it's very important. Dr. Nalapa Reddy, Sridhar Reddy versus State of Andhra Pradesh, reported in 2020 12 SCC 467. You should read this judgment. It's a very important judgment on section 216 CrPC. The next case one should look is the case of Mala Singh versus State of Haryana, reported in 2019 5 SCC 127. In this case, the Supreme Court discusses the circumstances under which a charge can be altered from section 149 to section 34 IPC. So, to further understand the concept which is expanded upon in section 216 of the CrPC, it is also beneficial to examine the following decisions. I have given the reference of the decisions in the screen. You may kindly look into this judgment. The first is Hassan Bhai's case, reported in 2004 5 SCC 347. Then Hariyar Chakrabarti versus State of West Bengal, reported in AR 1954 SC 266. Umesh Kumar versus State of Andhra Pradesh, 2013 10 SCC 591. The next is Kantilal Chandulal Mehta versus State of Maharashtra, reported in 1969 3 SCC 166. Amar Singh versus State of Haryana, reported in 1974 3 SCC page 81. Vimana versus State of Karnataka, reported in 2012 9 SCC 650. These are some of the judgments which one should look into to understand and grasp the proper concept which is elaborately discussed by the Supreme Court. So, to summarize today what we have discussed so far in regard to section 216 CrPC is that once the court noticed that there is some defect in the framing of the charge, then based on this legal precedents which I have discussed, the court has been granted significant authority to modify or add charges at any point before a judgment is pronounced. This may include after evidence is presented, arguments have been completed, or even when judgment is reserved. This power of the court to alter or add charges suggests the presence of elements of a different offence, because any added material which the court wants to do when they want to add or alter the charge, it must have direct relation to the alleged crime, because once the new charge is introduced, it virtually restarts the trial for those charges, and the duty of the court is to carefully assess whether the accused can be convicted based on the new evidence. So we should remember that although such power has been given to the court, this power of the court must be exercised responsibly so that no unfair prejudice against the accused is caused and the fairness of the trial is maintained. And suppose if the changes cause prejudice to the accused, the court may need to adapt its approach, possibly leading to a new trial or an adjournment. So, section 216 CrPC understanding is very important, because suppose new materials come before the court and the court frames a new charge. The court must hear the counsel of the accused that whether new charges, I have decided to add new charges, what you have to say on this point. Suppose the court decides to add or alter the charges, then the procedure prescribed in the subsequent section under section 217 CrPC has to be followed. Suppose a witness, only the examination in chief of the witness is taken by the court, and just looking into the examination in chief of the witness, the court finds that the original heads under which the charges were framed are defective or it needs to be altered or changed. The court can stop the proceeding at that point of time and then can add a new charge or alter the charge, and after that the cross-examination will start. So this is a very important concept during a trial proceeding in a criminal proceeding, because if you don't understand the concept of 216 CrPC, it may cause prejudice to the accused, and we must remain alert that when the court alters or adds charge, we must see that whether certain witnesses has to be recalled so that no prejudice is caused to the accused. So if you like our discussion on today's topic, please do comment and send your feedback to us, and please do not forget to subscribe to our Nyay channel, because it is with your support we are trying to improve on every episode. And now more than almost 2 months have completed, and we are trying to cover different topic, and we have also planned to start a new audio podcast exclusively for certain topics in vernacular medium, so that it becomes easier for the counsels who practice in the trial court to understand it. With this, I take your leave for today and hope to see you soon again in the next episode of Nyay.